All right, welcome to our May Bank Council Roundtable. This is the last roundtable before our usual summer break. Our topic today is all about guarantees. I'm Erin Bryan, a financial services partner in our Minneapolis office, and I'm going to kick things off today with a few housekeeping notes, and then I'll introduce our speakers. All right. The materials and attendance form are available for download from the Dorsey login. You should have received an email from dorseyu@dorsey.com. The speakers will not have time today to answer questions, but if you have questions, please feel free to reach out to them directly. Later in the program, a CLE code will be announced for attendees in states that require a code. A list of states where CLE credit is expected is shown on the screen and available in the materials. For CLE credit, please remember to return the completed attendance form to attendance@dorsey.com. All right, and now getting to the good stuff. I'd love to introduce our speakers today. We have three great speakers for you. They're all new to the Bank Council Roundtable, and they are lending transactions attorneys in our finance and restructuring group. I'll start off with Abby Fang, who is a partner in our Minneapolis office. Abby represents multinational companies, financial institutions, agent banks, and institutional investors in general corporate financing, cross-border financing, and acquisition financing transactions. Her experience also includes swaps and derivatives. Abby has over 10 years of experience working with leading international companies on various legal compliance issues. Her prior experience includes working as a regulatory analyst and associate in a major Wall Street firm's New York and Beijing offices. Abby also has experience in the Hong Kong office of a UK Magic Circle law firm and the Hong Kong office of a Paris-based investment bank. Next up is Laura Gunn. Laura is a partner in our Denver office. Laura negotiates and drafts loan documentation for syndicated, bilateral, subordinated, asset-based, and receivables warehouse credit facilities. Laura represents public and private companies, commercial banks, and financial sponsors in acquisitions, restructurings, and other complex commercial transactions. Before law school, Laura worked as a management consultant in the financial and consumer sectors. And then Joice Varughese is a senior associate in our Dallas office and a rising star in the firm. Joice represents commercial banks, private equity funds, and commercial borrowers in a variety of commercial finance transactions, including senior and subordinated debt transactions, asset-based and acquisition financings, and debt restructurings. Joice also has general corporate matter experience, including advising clients on entity formation and governance. And with that, I will turn it over to Laura.
Thank you, Erin. Good afternoon. We begin this discussion of guarantees with a rather flippant quote: "If you want a guarantee, buy a toaster." Many individual guarantors and even some institutional guarantors believe that limited guarantees won't in fact be called. In parallel, many creditors likewise expect difficulty with enforcement and thus seek to expand both guarantor liability and the number of guarantors signing the instrument. Today, we will review this evergreen topic, first considering the scope of limited recourse guarantees and negotiation points for both sides. Then, my partner Abby will discuss eligible contract participant rules for guarantors of swap arrangements and remind us of the recommended moves in credit facilities, such as excluding the swap obligations from the guaranteed obligations altogether, or building in ECP reps or a keep well provision. Finally, in our third segment, Joice will discuss guarantor defenses, waivers of those defenses, and related drafting tips. Now I will begin with a review of the current trends in limited or non-recourse guarantees. So what is a limited recourse guarantee? These guarantees are distinguished from both a traditional full recourse payment guarantee in which the lender may recover from the guarantor when the borrower fails to make payments due under a debt instrument, and also a true non-recourse guarantee in which a guarantor is not personally liable unless the guarantor is at fault in a specified way. The limited and non-recourse guarantees in the US, I'm using those terms somewhat interchangeably, were initially referred to as bad boy guarantees around 15 years ago in 2008 when this space kind of opened up in single family residential as well as commercial mortgage-backed securities. They used to be a one-page list of bad acts by an individual principal that would trigger the guarantee. Now they're more commonly called sponsor guarantees, as we will see sometimes the person or entity at the top is not an individual, but the sort of equity sponsor of the deal. The borrower in a credit facility supported by a sponsor guarantor is generally a special purpose entity into which project receivables are segregated. Given the self-contained asset pool, lenders often look to sponsors for additional credit support. In a simple structure, the sponsor signing the limited guarantee could be an individual human, like we were talking about with sort of the 2008 version, that holds all of the equity interests in the borrower. In a more layered structure, like we see in most real estate transactions today, the sponsor could be both the general partner operating the investment vehicle and, in addition, the limited partner entity that's making the lion's share of the equity contribution, usually, again, not an individual human being. In a classic bad acts guarantee, personal liability of the individual investor or investment entity at the top of the equity ownership chain would be triggered only when the sponsor guarantor committed a specified bad act and, in addition, that specified bad act directly resulted in a quantified loss to the creditor. As is common in other guarantees, consequential, punitive, and special damages are usually excluded. We'll look at some of the common applications for limited recourse or non-recourse guarantees. Historically, UK and EU real estate loans have been truly non-recourse, with correspondingly lower advance rates, while US loans can include a variety of guarantor liability arrangements that increase leverage, sometimes pushing the LTVs here much higher. In the US, bad acts guarantees arose in the context of commercial real estate financing and provided two categories of protection for lenders. First, as we saw on the prior slide, these sponsor guarantees allow the lender to recover its losses from the individual guarantors personally responsible for certain bad acts. Second, these limited guarantees typically include full recourse to the guarantor for certain additional actions that are under the borrower team's control, or sometimes not entirely, as we will see. Over the past 15 or so years since those one-pagers, US bad acts arrangements have settled on cost reimbursement for the really bad acts, including actual criminal conduct, and somewhat counterintuitively specify full recourse for the less bad acts, when viewed from a moral rather than economic perspective. Practitioners agree that bad boy guarantees are not meant to protect against market risk or otherwise provide full recourse to the sponsor. But there are some triggers in the less bad acts category that absorb an expanding amount of that market risk. The most common lending situations that employ a sponsor guarantee are CMBS, the SFR deals that I mentioned earlier, other real estate facilities. We also see this application in ABL, private credit, and private equity, regardless of sector. The commonalities among these applications are, first, that the borrower and sponsor's affiliates tend to fill multiple roles in the structure, some of which might have been filled by a third-party service provider under a traditional loan structure. For example, the sponsor's affiliates may oversee construction, design, or development of a project if you're working on something in the real estate space from the outset, or serve as a property or leasing manager for a real estate asset if you're working on an already developed project. The second commonality is that the underlying assets may be numerous, such as single-family homes or small ticket pieces of equipment, and thus cumbersome to secure directly, given titling regimes or even per-page filing fees. Perhaps you have had the experience of trying to file against mortgages in multiple counties or multiple states, or even in vehicle titling, and can see that that quickly becomes an inefficient way to handle the collateral arrangements. So, what is a bad act? We're starting with the intentional actions list. This is the original bad acts umbrella, and it encompasses actions by principals controlling debt arrangements and borrower performance that prevented payment of the debt when due or negatively affected the value or availability of the collateral. A representative limited recourse guarantee that I negotiated for a borrower side fund this year contains this standard collection of misdeeds, following which the guarantor is responsible for ordinary damages resulting from the fraud or other bad act. So we have fraud at the top, misrepresentation, which can include misleading statements, can be specified as verbal or not, written, formally delivered in financials or not. Misappropriation, which could be of the income from the underlying assets in a receivables facility or of specific purpose reserves. For example, you might have a bucket for insurance, condemnation, or remediation proceeds that's required to be used or topped off in a particular way. That can trigger the misappropriation prong. We also have waste or transfer of collateral or other business assets. So this is generally, the standard covenants that you'll have in your loan agreement or security agreement that just relate to protecting the value of the collateral. This would be separate from market events in terms of a general effect or a general downturn, but anything that's specifically done on this intentional actions list. We also have the classic felony or misdemeanor crime, which was the subject of those early one-pagers. So that's kind of always been the feature when you're thinking of an individual principal sitting at the top and something that individual might do that would trigger full recourse back up to that person. We have a breach of key reps and covenants, and those are almost always the SPE or collateral provisions. So the collateral provisions are the ones that we discussed a moment ago, and then the SPE would be the things you would expect, like separateness and preserving the structure and the dedicated bank accounts and the funds flow that goes with the entire structure. So next we talk about what I'm calling bad circumstances. So this is where when you move past that one pager that started the bad acts guarantees, we have kind of a second list. And I've called this the stuff happens list because the idea is that these are things that may touch on broader systemic secular trends or that may be intentional, and the negotiation points kind of lie in the gray space between those. So over the last 15 years, the list of circumstances that have been included in bad acts guarantees has expanded to include events that are not, in fact, intentional bad acts, though they still get the historical title because they appear alongside the original set in most limited recourse guarantees. These circumstances range from borrower-side collusion in bankruptcy to situations over which the principal guarantor has little control. The standard limited recourse guarantee that I mentioned then, after the collection of the usual fraud and misrepresentation events, outlines the voluntary or collusive involuntary bankruptcy events that would trigger the guarantor's financial backstop of the SPE's obligations. Each prong details some element of cooperation by the guarantor or the SPE and excludes standard responsive moves. For example, the guarantee that I mentioned on the previous slide includes a full recourse event for involuntary bankruptcy proceedings for which an SPE affiliate entity participates in the filing. So that involves some amount of cooperation. And then it carves out other than for the sole purpose of maintaining standing to seek relief from the proceeding. So you wouldn't trigger it by responding to a filing, but anything in the pre-filing or initial filing stage would be considered cooperation with an involuntary proceeding or whatever other collateral action was taking place. And then any involuntary proceeding, we're sometimes seeing those now included. And so we'll talk about this in a moment with negotiation points, but from the borrower side, this is something you really want to look at because this is where we're starting to get into reallocating general sector risk, which you may want to do or may not want to do, but at least you want to make a conscious choice about what you're doing. In addition, some sponsor guarantees include occurrences that may not be entirely intentional, such as a lien filing by a third-party contractor or judgment creditor, or the release of hazardous chemicals. So oftentimes before these bad acts guarantees were standard, you might have a standalone environmental indemnity agreement that served the same purpose with respect to an environmental indemnity breach. So these are often rolled into kind of the bad circumstances section because it's agreed that it's not really changing the allocation of risk, since in the status quo before these guarantees, that risk was assumed even if it wasn't intentional or even remotely related to the conduct of the borrower. So the environmental indemnity piece is kind of a separate special category where even though it's often not intentional on the borrower's side, it's kind of agreed that it's market to include it. Each of the batch of publicly filed sponsor guarantees that I reviewed from this year includes all of these bankruptcy triggers. Though some are more explicit that the sponsor action must be proactive or collaborative with that of the filing entity, none of the 2023 guarantees included the third-party actions, with the exception that I had mentioned of a few that provide full recourse for environmental losses experienced by the lender, whatever their source or whatever the degree of the borrower team's culpability. So some of you might recall perhaps the last time that you revisited this topic, it might have had to do with some uncertainty that was created in a pair of famous Michigan cases from 2011. I've called this the expansion pack because there was a brief moment in the sort of early history of these bad acts guarantees in which a couple of cases decided by a Michigan state court and Michigan federal court, unrelated, they both happened to deal with a commercial mortgage loan that included a solvency covenant. So of course, these covenants will be common in loan agreements. You'll often see them in the events of default section, and that will say simply that if the solvency test is failed by the borrower at whatever the specified determination date, sometimes that in and of itself can be an automatic default and trigger ordinary recourse there. The question here is whether that default would trigger liability under a limited guarantee. The idea being that it doesn't really touch anything that has to do with the intentional actions of the guarantors or really the collateral necessarily even itself. So in these two cases, the court took a pretty expansive reading and they allowed full recourse to the guarantors for the deficiency that remained following the foreclosure of a shopping center property. Each case involved a separate shopping center property. So the idea was the court basically said that these solvency covenants, again, reading broadly, were, part of that list of key covenants and reps that we usually would tend to read as only including the SPE covenants or reps made about the collateral, the property, the underlying assets themselves. So today, as we'll see shortly as we talk about negotiation here, the idea is that you'll definitely want to thoughtfully spell out exactly what reps and covenants are key, and that's why these are no longer one page, they're 20 or so, to refer to all the covenants in the loan agreement, the security agreement, and the other collateral documents that you want to include. So following those 2011 decisions, Michigan itself seemed to agree with the practitioners and the somewhat frantic borrower side funds that this was out of step with the market expectations. The expectation wasn't that it was every single covenant breach would cause full recourse to the individual guarantors. So the Michigan legislature deemed solvency covenants insufficient to trigger this kind of recourse liability. So that is a statutory protection that now exists in Michigan. And then the subsequent case law since then has completely removed market risk from the limited guarantee triggers. So, for example, some of you may also have, the last time you revisited this, looked at a representative Florida case from 2013. Same facts, another shopping center complex, another bank lender. And in this case, a 2013 Florida court applied the New York governing law of the loan documents and said that the sponsor guarantee was not triggered by the SPE's insolvency. So the consensus is that the allocation of market risk will not be inferred, though it can certainly be explicitly divvied up, as we had discussed. I think the takeaway here is that if you have any memory from past CLEs or reading about this topic, I think the cases since 2013 have all been in the same line as 2013, saying, let's look at the four corners. You have to be extremely explicit, and we're not going to infer kind of this broad market style liability if it's not clearly written there. So that's kind of the takeaway. And on the next slide, we'll talk about the risk shifting considerations. So these are the negotiation points that I had mentioned earlier. Really here from the lender's side, when you're negotiating a limited recourse guarantee, you of course must insist upon the classic bad acts list, fraud, misrepresentation, and so on. And this will provide recourse again for the specific loss incurred by the lender. So that's that first category of losses where the quote really bad acts like the crimes and frauds and so on will get full recourse for the exact damages that they've caused. So you, as on the lender side, you're proving out the damages and you're thinking about what those might be, and you're building all of that in and being pretty explicit about it, making sure that none of it gets caught up in the special or punitive damages category, or that if you think it might, that you provide for that. So that's kind of the classic first move. And then the second side, where you really have an opportunity to kind of customize your guarantee for your borrower relationship, for the sophistication, for how deep the pockets are. That's where you bring in these sort of full recourse events where you get not just the specific damages, but if triggered, you get entire full recourse up to the principal, individual, or entity, the investment fund behind the borrower's capitalization. So this is the collaborative bankruptcy events that we had talked about, but it can also include those kind of gray area items from the stuff happens list where there could be some borrower fault, or maybe there isn't. You know, sometimes you have a covenant about no liens, for example, getting filed on the collateral, and maybe a contractor files one, and it, you know, does that trigger full recourse? These are the kinds of things you want to think about. I think the market is not there that's the standard, but it's certainly moving toward more risk. So reallocation to the borrower in that way. So they're saying, you know, as between the borrower and the lender, that the borrower should bear the risk that, you know, the third party contractor or judgment lien holder, you know, files that lien. So these are the kinds of things where there's definitely room from the lender side to expand this. So consider how much sector risk you want the guarantors to bear and make it explicit in the guarantee triggers. Then you might take a step back. If you find that you really want a traditional guarantee, then maybe just forget this last 15 minutes and negotiate for that, because sometimes as you keep expanding the list of these sort of market related triggers, you'll realize actually we're wanting the deep pockets to just be on the hook in a traditional way. So maybe think about that too. Then from the borrower's side, you'll want to scrutinize the proposed bad acts list for items that aren't reasonably within the borrower's control. So you really can't get rid of that first category, the things that are kind of on the one pager, but what you can do is really go where the market is moving and say, you know, right now, it definitely can't be said that it's market yet, though it's not unheard of to have some of these third-party events trigger full recourse. So that's really where, from the borrower side, your negotiation efforts should focus. For example, there could be a real estate market downturn that could cause an SPE to be the subject of an involuntary bankruptcy. So the bottom line on the borrower side is that ultimately, if your principal, especially if you're dealing with a smaller structure with, you know, an individual human being at the top of it, and that person cannot accept full recourse, then, you know, you can't sign that sort of expanded limited guarantee, and you certainly can't accept a traditional guarantee for that person. So with that, I will turn this over to my colleague, Abby.
Thanks, Laura. I'm going to talk about the impact of eligible contract participant rules on guarantees. The rules on eligible contract participant, or ECP for short, are not something new and were published quite a while ago. Solutions to minimize the unintended impact of eligible contract participant rules on loan documents have been quite marked as well. But in practice, we notice that sometimes provisions resulting from compliance with ECP rules are misused. So I wanted to take this opportunity to provide a refresher here. Before getting into the specifics on eligible contract participant rules as a general background, I wanted to briefly talk about loan-related hedging, To manage the risk and ensure certainty, borrowers by themselves or sometimes as required by lenders to hedge against the risk of changing rates like foreign exchange rates or interest rates. Given the time limit, I will not get into the details on whether some foreign exchange rates will fall under the CFTC's mandates. So today I will be focusing on interest rate hedging, since this is also the most commonly used and required hedging in connection with loans, and most of it should fall under the CFTC's mandate with some really rare exceptions. Interest rate hedging takes different forms. For those entered in connection with loans, they're usually quite vanilla, including interest rate cap, interest rate collar, and interest rate swaps, and so on. In interest rate cap and interest rate collar, the borrower pays the swap provider a premium, and the swap provider in turn protects the borrower from the fluctuation of interest rates. For example, in an interest rate cap, the borrower doesn't have to pay the difference between the actual interest rate and the pre-agreed interest rate cap if the actual interest rate exceeds the pre-agreed interest rate ceiling. And in an interest rate swap, the borrower doesn't have to pay a premium, but it simply has to pay a fixed rate, and the swap provider will take the risk and benefit as well of the floating interest rate, which is usually the interest rate in the loan documents. So in essence, those interest rate hedging products are offered to provide borrowers with certainty and protect the borrowers from changing interest rate market. And most of the interest rate hedging transactions entered in connection with the loans are over the counter. That is to say, they're not traded or on a designated contract market or centrally cleared. Next. So interest rate hedging transactions, like other derivative transactions, are usually documented separately under the preprint ISTA master agreement, with elections made in ISTA schedules and trade-specific terms documented under the trade confirmations. Usually, swap transactions like loan transactions will have credit support as well. For loan-related hedging, the credit support of swap obligations and the loan obligations are usually under the same document, which may be embedded in the credit agreement or in a separate guarantee or security agreement. However, given the nature of the products offered, even though swap obligations and the loan obligations usually share the same credit support, it is usually different teams within the bank that takes care of those products. And this results in different procedures in terms of KYC and onboarding. Next. So what is the relevance here? If a borrower wants or required to hedge its risk, it will just enter into some over-the-counter interest rate swaps or caps or collars with the swap provider. And the swap provider sometimes are the lender or lender's affiliates, and they will get benefit from the credit support provided by the loan parties as well. So it seems quite simple, but the financial crisis in 2008 changed the game, and we now have Dodd-Frank. Section 723A2 of the Dodd-Frank Act amended Section 2E of the Commodity Exchange Act, provide that it shall be unlawful for any person other than an eligible contract participant to enter into a swap unless the swap is entered into on or subject to the rules of a board of trade designated as a contract market under Section 5 of the Commodity Exchange Act. Now you may wonder, a guarantor of swap obligations is not entering into a swap themselves. Do they have to be an eligible contract participant? The market back then had the same question. So then in 2012, in CFTC letter number 12-17, the Office of General Counsel of CFTC clarifies that each guarantor of a swap must be an ECP unless the guaranteed swap is entered into on DCM. So in plain language, it means that the swap guarantor must be an eligible contract participant unless the guaranteed swaps are traded on a platform or in exchange, subject to the regulatory oversight of CFTC. So as mentioned previously, most of the loan hedging transactions are executed over the counter, not centrally cleared or traded on a designated contract market. So this means that the swap guarantor of over-the-counter swaps in loan hedging must be an eligible contract participant. Next, please. So what is an eligible contract participant? This term is defined in the Commodity Exchange Act and CFTC regulations. It was designed to limit the availability of non-DCM listed swaps to market participants of sufficient financial sophistication and with sufficient assets or net worth to access, appreciate, and bear the implication and the risk of swap transactions. So CFTC's logic is that guarantor of swaps assume and bear the risk of the swaps that they guarantee. Therefore, the guarantor should be sophisticated enough as well. Although the no action letter didn't expressly require security provider that grant a security interest to secure the swap obligations to be in an ECP, this logic seems applicable to security provider as well, because the security provider of swaps assume and bears the risk of the swaps that it grants security interest for. Therefore, lender should consider to limit the obligations secured by a security interest from non-ECP loan parties so that it only secures the loan obligations and not the swap obligations. Next. So how can a party qualify as an ECP? There are various ways for a party to be qualified. The most straightforward way is to look at the total asset. Companies, organizations, trusts, entities with more than 10 million in total asset, or any entity guaranteed by such entity could be considered as an eligible contract participant. Or we can look at the net worth. Entities with a net worth of at least 1 million that are hedging commercial risks can be considered as an eligible contract participant. There are some other ways that we are not going to elaborate here today, but the gist is to make sure the market participants are sophisticated enough to take the heightened risk associated with swaps. Those standards can be difficult to meet depending on the deal structure, particularly in loan-related hedging. It is common in loan transactions that each subsidiaries of the borrower or sometimes affiliates of the borrower to guarantee the loan with security over their assets. Not all of those subsidiaries or affiliates could qualify as an eligible contract participant. Then what would be the consequence for a non-ECP to guarantee or provide security for the swap obligations? Next, please. The guarantees in connection with the credit agreement may be unenforceable due to illegality to the extent the guaranteed obligations include swap obligations guaranteed by non-ECP loan parties. Also, because loan guarantees are rarely severable, there is a risk that the entire loan guarantee could be rendered unenforceable. In other words, the enforceability of a non-ECP's guarantee of loan obligations in whole may tainted by the non-ECP status of the guarantor with respect to the swap obligations. The same probably applies to the security agreement as well if the swap obligations are secured by a non-ECP loan parties. Additionally, the swap provider that is a swap dealer and violates this rule also face potential CFTC enforcement action And this is concerning from a bank's perspective as well. Therefore, if any swaps are offered as cross-sale within the bank, it's always important to make sure the swap side is aware of the disclosure made by the borrowers and guarantors on the loan side, and then vice versa. Next, please. So with the consequences in mind, what can we do to avoid it? First of all, I wanted to clarify that no separate actions are required if there's no swap products offered in connection with loans. But if after the communication with the swap side, you are aware that the bank is offering swap products, then on the loan side, the lender should have considered the following options. First of all, lenders can ask for representations from loan parties that they are eligible contract participants in the credit agreement, because as mentioned previously, it's usually a different team within a bank working on the swap side. The onboarding process on the swap side may not be as extensive to cover all subsidiaries or other loan parties on the loan side. So it's always nice to have all loan parties to make representations as to their ECP status. However, as the rule tests ECP status each time, each time a swap is entered into, and the swaps are frequently entered into after the date of the credit agreement. So obtaining representations as to ECP status for each loan party at the closing is only a partial solution. Lenders can also ask for ECP status to be conferred by one loan party that isn't an ECP to another through use of keep well agreement or a keep word clause. The usual keep word clause provides that the qualified ECPs undertakes to top up assets of a non-ECP to honor its obligations in respect of a swap obligation. But this can be a partial solution as well, because you will need at least one ECP loan parties to confer the ECP status. Another common approach is to simply carve out swap obligations that becomes illegal because of the non-ECP status from the definition of obligations in the credit agreement. Such excluded swap obligations should also be carved out from the guarantee and probably the security agreement as well. Sometimes this can be achieved by simply relying on the definition of obligations in the credit agreement that has already carved out the excluded swap obligations. But sometimes, if the guaranteed obligation or secured obligation are separately defined in these documents, the excluded swap obligations should be expressly carved out under those separate documents. LSTA has published a market advisory in 2013 with suggested definitions to carve out non-ECPs and optional keep well provisions for insertion into guarantee. Those terms are now very common and widely accepted. It is the best practice to keep an eye out for those provisions to make sure a non-ECP are properly excluded. And as suggested by LSTA, care should be taken to make sure that swap providers are excluded from sharing in the proceeds of guarantees and probably collaterals provided by a non-ECP. Note that all those solutions and approaches are not mutually exclusive. We see most of those provisions in loan documents at the same time. Now, I will hand it over to Joice for her to talk about surety, defense, and waiver.
Hi, everyone. Thank you, Abby. Now, guarantees, as we've just spent about 40 minutes speaking about, they've commonly been part of the standard loan documentations. We see them commonly. Guarantees, getting a guarantee is part of the lender's underwriting. So I'm going to be spending some time talking about suretyship defenses and waivers. We're talking about defenses that arise out of suretyship principles, since it's one of the ways that a guarantor's liability can be limited. And we'll also discuss waivers that should be included in the guarantee agreement. The principle of suretyship is a common law principle. It does vary from state to state. However, I'm going to spend some time looking at California in particular, because California has codified the suretyship principles, and the California statutes are a good guideline to look at when we are negotiating guarantees, when we're drafting or reviewing guarantees, and will give us a good idea of the waiver language that should be included in the guarantees, regardless of whichever state choice of law governs. Next. Okay, so guarantee versus a surety. Now, both guarantees and sureties are forms of security for a principal obligation. A guarantee creates an independent principal obligation. That's the key characteristic of a guarantee. Legally, a guarantee is the contract of a guarantee is deemed to be a separate and independent from the contract that's made by the borrower in signing the note or the loan agreement. We often see absolute and unconditional language in a guarantee, meaning that the guarantor undertakes to repay the borrower's debts upon default, regardless of any claims or defenses that may belong to the borrower. Now, in contrast, a surety creates an accessory obligation. There is no surety if there is no principal obligation, and we often see this addressed with language in a guarantee that says the guarantor is acting as a co-obligor and not merely as a surety. While not every surety is a guarantee, guarantees are surety contracts, and the legal effect of giving a guarantee is that the guarantors become a type of surety. Next. What are suretyship defenses? We're talking about defenses which the guarantor may have or that may assert against the enforcement of the guarantee based upon suretyship principles. These stem from the premise that the surety has rights against the primary obligor, which is the borrower. If the surety is forced to pay the lender because the borrower does not, the surety has a right of subrogation, meaning that the surety can ask for reimbursement from the borrower. Now, suretyship defenses are meant to protect the surety from actions that would alter its rights and put the surety in a position that it did not originally believe to be part of the bargain. If the lender modified or altered the guaranteed obligation or any security that's granted in connection with the guarantee, without the guarantor's prior written consent, the guarantor or the surety can argue that it only guaranteed a specific obligation and not one that differs from the original undertaking in any respect. Next. Okay, so I'm going to go through some common suretyship defenses. I've listed them here. I won't discuss every single one in detail, but I'm leaving them here so that you can refer back to the presentation. The first one that I will discuss is material alteration of underlying debt or of the borrower. Now, we're talking about material changes that increase a guarantor's risk of loss after execution of the guarantee. So such material changes can include the amount or timing of payments or increase the amount of debt or the interest rate. When we talk about material alteration of the borrower, we're talking about things like the borrower merging into or with another entity, which can increase the guarantor's risk, especially if, as a result of the merger, there is a change in management, control, operating procedures, or other business dealings. Another defense is defenses that relate to collateral, including the failure to perfect. So if a loan has sufficient collateral and it is adequately secured, there is less risk that the lender will look to the guarantor for payment because in theory, the lender should be able to collect the amounts owed to it from the proceeds of the collateral. But if the lender went ahead and released some or all of the collateral without the guarantor's prior consent, or if the lender fails to realize on the collateral because it didn't file a proper financing statement or record a mortgage, that increases the guarantor's risk of loss. Release of the borrower or co-guarantor is another one. Whenever a lender releases the borrower, under the suretyship principles, the surety is discharged unless the surety consents to remain liable or the lender expressly reserves its rights against the surety. When there is more than one guarantor, a guarantor generally has the right of contribution from the other co-guarantors, with each co-guarantor being liable for its pro rata share of the total liability. Each co-guarantor is likely to be jointly and severally liable to the lender for the full amount of the guarantee. And if the lender releases one co-guarantor, this increases each of the remaining guarantors' risk of loss. Failure to notify the guarantor of the debt, or failure to notify the guarantor of the borrower's default, and failure to notify the guarantor of adverse matters or material facts is another defense that a guarantor can raise. Next. Okay, so as I previously mentioned, while the principle of suretyship is state law, I'm going to just look at California in specific. Because California has codified the suretyship principles in California Civil Code sections 2787 to 2855, it's a good guideline to look at, especially when you're thinking about issues that can arise with the guarantee and material obligations of the obligation, the collateral, the parties, etc. These statutes in the California Civil Code expressly grants legal rights and defenses to the surety. So for example, section 2809 limits the obligation of the surety if the surety's obligation exceeds that of the principal debtor. 2810 relieves the surety if there is no liability on the part of the principal at the time of execution of the contract, or liability of the principal thereafter ceases. Section 2819 exonerates a surety if the lender, without the consent of the surety, alters the principal debtor's obligations. Section 2845 exonerates the surety if the lender does not pursue the principal debtor first or impairs the surety's subrogation rights. Section 2845 allows the surety to exercise every remedy against the principal debtor that had been available to their creditor after the surety satisfies the principal obligation. Next. Okay, a waiver of defenses. The good news is that while all of these defenses are available to the guarantor to limit its liability, the guarantor may waive most, if not all, common law defenses by express agreement. The waiver of defenses, as we discussed, is needed to ensure that the guarantor's liability is not limited. And broad suretyship waivers should be included in the guarantee. This will allow the lender to modify the underlying loan documentations without having to worry about whether the modification will absolve or discharge the guarantor from its obligations to the lender. Next. Okay, so here is sample, like, broad waiver language. We want to make sure that something to this effect is included in all guarantees that we are drafting, negotiating, thinking about, etc. So it says the guarantor shall not be exonerated with respect to the guarantor's liabilities under this guarantee by any act or thing except irrevocable payment and performance in full of the obligations, no invalidity, irregularity, or unenforceability of all or any part of the obligation or of any security therefore or other recourse with respect thereto will affect, impair, or be a defense to the guarantee. The guarantor expressly waives any and all defenses of the borrower pertaining to the obligations, except for the defense of discharge by irrevocable payment and performance in full. So in addition to broad waiver language like this, we'll also want to have, in addition, waiver language that specifically targets the other common defenses that I previously mentioned, something to the effect of the liabilities of the guarantor will not be affected or impaired in any manner by any modification, any extension of the obligations, the loan documents, et cetera. And we'll want to make sure that there is waiver language that specifically targets the other defenses as well. Next. Okay, and similarly and in parallel, California has also codified the principle that a guarantor can waive its rights and defenses that are available to it under the California Civil Code, and we find that in section 2856. Broad suretyship waivers of rights and defenses would be considered presumptively valid, and makes clear that any guarantor or other surety may waive any or all of its rights of subrogation, reimbursement, indemnification, and contribution, and other rights and defenses that are or may become available to the guarantor or other surety by reason of sections 2787 to 2855, which are the suretyship rights statutes. Next. Okay, now a word of caution about waivers, and especially waivers that have this broad language. And even if we have broad waiver language and we have specific waiver language that targets each of the suretyship defenses, it's not a waiver of all defenses, especially defenses that arise out of equity, such as unclean hands or fraud or improper acts on the part of the lender. And so that's the first case that's quoted here. A waiver of statutory defenses is not deemed to waive all defenses, especially equitable defenses, such as unclean hands, where to enforce the guarantee would allow a lender to profit by its own fraudulent conduct. And so that's another thing to keep in mind, that there are other waivers that may specifically need to be mentioned and included aside from what's been discussed here. And similarly, absolute and unconditional language may not in and of itself waive a defense based on the statute of limitations or other defenses that relate to enforcement or to legal action. Next. Okay, so now in summary, some practice tips for negotiating and drafting guarantees. Laura mentioned earlier to consider whether a true bad acts guarantee, a hybrid limited recourse guarantee, or a traditional full recourse guarantee best suits the deal. These are things that should be considered. In addition, think about dividing the list of bad circumstances and market risk among the parties. Include broad waiver language, waiving the statutory defenses and the common law defenses. And another best practice is to still go ahead and require guarantors to reaffirm and ratify the guarantee obligations each time you're doing a modification or an amendment of the underlying debt, so that the guarantor is notified of what's happening and they've reaffirmed and there is no question of their guarantee obligations. Okay, next. Okay. I think we may have some time for questions since we're a few minutes ahead of schedule.
So I think Laura had some questions for Abby and Joice. Laura, if you're still on.
Yes, thank you, Erin. Since we had a couple extra minutes, I just wanted to ask a couple of follow-up questions, one of each of you that kind of came up for me as I was listening to your presentations. So we'll just take it in order, and I'll start with Abby here. Abby, I noticed that you had mentioned the LSTA ECP provisions, and I remember when those came out a few years back, I spent a lot of time, as probably everybody did, really trying to drill down and understand them. And then I have to admit that now, especially when I'm lender side, I just kind of, skim it and assume it's fine. And so my question actually is more on the borrower side. You were talking a bit about how there can be situations where the guarantor isn't eligible, or there could be other issues with just kind of relying on the standard language. And so I guess my question is there something in particular that anybody representing a borrower or borrowers themselves or the guarantors themselves should be mindful of, or are they kind of in the lender boat where they can just say, yeah, this is what it is?
Yeah, so the ECP compliance issues is more important to lenders because lenders is usually the swap dealer, and lenders it's more concerned of the enforceability of the guarantee and the security agreement. And given that it has been well established in the market, we didn't see a lot of room for the borrower or the guarantor to negotiate the standard language that's recommended by LSTA. But I think as an overarching principle, the borrower or the loan parties should at least ensure that they are making the right representations. And also when if there is a keep well clause there, they need to make sure that they can actually to confer the ECP status by topping up the assets to and non-ECP loan parties there.
Thank you. And Joice, I'm actually going to ask you a kind of similar question, which is when I'm reviewing guarantees, I often find on the last page, there's like, I don't know, a page and a half that says Arizona specific statutory provisions. It might literally just say that, or California or whatever that, and then you'll just see, a reference to 14 statutes that are waived or something like that. And so again, I'll confess, my practice from the borrower side is that I'll take a look at each statute, and then if something seems overbroad, especially if it relates to like interest, usury, those kind of things, then then I'll strike it as inappropriate. From the lender side, I tend to think, no harm, because it's better to be overbroad, and then maybe it just wouldn't be enforceable is like the worst thing that could happen. So might as well include it and potentially get the benefit. Is there any risk with that approach, from the lender side, or can I just, throw the entire, statutory references on the back of every guarantee?
Yeah, that's really the approach from the lender side. There's no consequences to being overbroad, and that's what you want to do, is try to include everything and some more, so that at the end of the day, the guarantee will, stand as much as possible. And if it's enforceable, if the waiver is enforceable, it would have been anyway, and including that language in the guarantee is not what's going to make it unenforceable.
Great, thank you.
Well, I really appreciated hearing from all three of you. It's great to have some new perspectives available for our audience. And so thank you for your time today. I did also just want to remind folks who are attending that we are taking a summer break. So it will be a while before you hear from us again, but we look forward to reconvening at the end of the summer. And then also just a reminder that if you need credit, you do need to return that attendance form to attendance@dorsey.com. If you have questions, you can follow up with the presenters directly or reach out to your Dorsey contact. And the materials and sign-in are available from the Dorsey login and materials email sent from events@dorsey.com. And the program recording for this is available. So if you want to go back and review any of the material or forward this to another contact of yours, that will be made available afterward as well. So thank you so much to our presenters and to the audience for your time today. We learned a lot, and we will see you again in a few months.
Thank you.